Okay, good morning, good afternoon, good evening to you, dear colleagues, and welcome to this webinar. I'm Pierre D'Argent, I'm the current president of the European Society of International Law, and it is my great pleasure to welcome you at this webinar, which aims to take stock and to provide a preliminary assessment of the new BBNJ treaty. When the BBNJ treaty negotiation cycle was finally and positively, hopefully concluded a little more than a month ago, this sounded like a good news to the world and in the midst of a very troubled and grim time. And therefore, I reached out to my colleagues, Irini Papanikolaou, Gabriele Awanta, Jessica Scheslinger, and Akis Papastavridis, who are the coordinators of ESIL Law of the Sea Interest Group, in order to set up a webinar at short notice. And my colleagues were generous enough, and I'm very grateful to them. They were generous enough to and to act upon it, and to set up this webinar with the support of ESIL's Secretariat. And the webinar will take the form of a conversation with our three guests that my colleagues will further introduce, but I want to welcome them, of course, very warmly first. And we have the privilege of hosting today first Madame Gabriele Goettsche-Wanli, who is a former director of the United Nations Secretary Division for Ocean Affairs at the Law of the Sea at the UN. We also have His Excellency Konrad Marciniak, who is Director of the Treaty and Legal Department at the Polish Ministry of Foreign Affairs. And last but not least, we are privileged to host Tladi, who is our colleague, Professor of International Law at the University of Pretoria in South Africa, also a member of the International Law Commission, and I'm privileged to be his confrère at the Institut de Droit International. Welcome, very warm welcome to the three of you, and thank you so much for having accepted our invitation and for taking the time to participate. The webinar was also originally supposed to host a fourth speaker in the person of Christina Gjerde, who is Senior High Seas Advisor at the Ocean Team of the International Union for the Conservation of Nature. But unfortunately, for personal reasons, she isn't unable to participate today to our webinar. And this is, of course, very unfortunate. We will miss her views on the new treaty, but at the same time, we have to take to look at the bright side of things. And the bright side of things, in a way, is that it will provide more time for each of our speakers and for the audience also to put their questions and for those questions to be answered. So again, thank you very much for your presence. Thank you, colleagues, for your participation to the webinar. And without further ado, I give the floor to my dear colleague Irini. Please, Irini, the floor is yours.
Thank you very much, Pierre. As mentioned, I'm Irini Papanikolaou. I'm a British Academy Global Professor of International Law at SOAS University of London and a member of the Coordinating Committee of the Interest Group on the Law of the Sea of the ESIL. And together with my colleagues, Akis Papastavridis, who is a researcher and lecturer at the University of Oxford and research fellow at the Athens Public International Law Center, and Gabriele Awanta, who is an associate professor of public international law and international relations at the University of A Coruña, and both members of the Coordinating Committee of the Interest Group on the Law of the Sea, we will moderate this webinar. Now, the BBNJ treaty, the text of which was agreed upon just a month ago, testifies to the commitment and dedication of the international community to lawmaking and multilateral efforts. The BBNJ treaty took almost 2 decades in the making. In 2004, the UN General Assembly first established a working group to study issues of biodiversity, conservation, and sustainability on the high seas. In 2015, the General Assembly decided to establish a preparatory committee to make substantive recommendations. In 2017, again, the General Assembly decided to convene an intergovernmental conference to develop a legally binding instruments. Negotiations, as provided for in the resolution, were to address the topics identified already back in 2011, namely the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, in particular, together and as a whole, marine genetic resources, including questions on the sharing of benefits, measures such as area-based management tools, including marine protected areas, environmental impact assessments, and capacity building and the transfer of marine technology. The first session of the conference was held in 2018, with subsequent sessions in 2019, 2022, and 2023. Following lengthy and complex negotiations, on 5 March 2023, states agreed on the text of the treaty. Although the treaty is not formally adopted yet, my colleagues and I really agreed with the ESIL president that it is worth holding a first discussion to assess the outcome of so many years of negotiations. We are delighted to have an excellent panel to do so today, as our speakers are among the most qualified to discuss the new treaty. Gabriele Goettsche-Wanli actually has spent almost all her career working on ocean issues at the United Nations. BBNJ is very close to her heart. She has been working on BBNJ issues for close to 20 years, first while working in Doualos, including as a secretary of the BBNJ Intergovernmental Conference. And then following her retirement, she has moderated several dialogues on the issue during the High Seas Treaty Dialogues, amongst other activities. Konrad Jan Marciniak currently advises the government of Poland on the whole range of issues involving the application of international law, including in particular on the law of treaties, issues related to the law of the sea and environmental law. He also represents Poland in a number of fora, including the BBNJ negotiations, to which he has actively participated for all the period of the negotiations. Konrad also has authored or edited a number of books and scholarly articles, especially on the law of the sea. Tladi is professor of international law in the Department of Public Law and a fellow at the Institute of Comparative and International Law in Africa. He has served as the principal state law advisor for international law for the South African Department of International Relations and Cooperation and the South African Permanent Mission to the United Nations. He has actually been involved in the BBNJ negotiations from the very beginning, as he was first a delegate for South Africa to the meetings of the committees since 2006, and then he has been acted as a consultant for an NGO during the formal negotiations. So we look very much forward to hearing what they will tell us about this new treaty. But before that, let me just mention a couple of housekeeping rules. The chat box is disabled, and you are all welcome to use the Q&A box for posing questions. Questions will be answered after the round of the table, and we hope that we will have lots of questions and lively debate. And now let me turn to Aki. Aki, you have the floor.
Thank you so much, Irene, and thanks to Pierre and all our very, very prestigious colleagues, and that they have accepted to join us in this webinar. We are fortunate that Christina could not join, but we will. I think we'll have a very fruitful discussion. Without further ado, I will just start actually the roundtable. So what we have thought of is to frame this upon certain questions that we're going to ask to the speakers, the panelists, and then of course they were very free to discuss among each other and offer their views on comments on the previous speakers. And then when we close this line of questions and the comments by the panelists, we'll open the floor to for Q&A to the audience. So the first issue that I'd like to ask to our panelists, this is just also for people there they're not very familiar with the new treaties, is what are the main features of this new agreement? If you can like to describe it to a friend of yours, to a colleague of yours who is not well versed in BBNJ, what you will tell to him or her about what are the main features, what are, in a few words, what is all this treaty about? Why we negotiate for 19 years this particular treaty? So I will start with this very short question or difficult question with I will start with Gabriele first.
Thank you very much. So what are the main elements and why did we negotiate this treaty? I guess what I would say is, I mean, the main purpose of the treaty was really to sort of fill what most of us recognized as a void, actually two voids, in the law of the sea regime. In the beginning of the negotiations, or at least the discussions, because initially it wasn't negotiations. At the beginning of the discussions, there were some that took the view that there was a gap in the law of the sea framework, in that there was nothing that told us how to deal with marine genetic resources, right? So, or at least how to deal with marine genetic resources in the area. So it was clear that there was a particular legal regime governing the area. But that legal regime, when it came down to specificities, spoke only about some mineral resources, which seemed to leave open the question of marine genetic resources. And so there was a great debate. There were some that took the view that even though marine genetic resources appear to be excluded, or actually are excluded by the language of the treaty, they are still in fact covered by that legal framework. But on the other hand, there were some that says, well, I mean, if the treaty is clear that it's excluding them, then of course, by definition, it means that they're not included, which means that they're covered by a different part of the Law of the Sea Convention. And so that was the first gap. The other gap was not so much a gap based on disagreements. It was a gap based on, I guess, agreement between all the parties that the Law of the Sea Convention permits states to take measures beyond areas of national jurisdiction, but those measures would only be applicable to those state parties, which creates, if you like, a sort of a prisoner's dilemma, right? So the good states will adopt measures to constrain themselves and their nationals, and the bad states will then act as free riders because they won't be bound by those, but they'll still benefit. So it was really these two issues that these discussions attempted to address. So I won't say more because I'm sure there's more to say, but I'm sure also I should leave something for my panelists to also say something.
Thank you so much, Gabriele.
Thank you. And let me just say, first of all, what a fantastic achievement it was to conclude that treaty after all those years. Not to be underestimated, the complexity of the issues that needed to be covered and needed to be addressed. I think Gabriele has already touched upon the regime governing the marine genetic resources in areas beyond national jurisdiction, and also I should also include, and that is included in the treaty, is digital sequence information on these marine genetic resources. But let me highlight perhaps also the other major achievements, and certainly what wasn't there before is that the treaty established a global regime for establishing area-based management tools, in particular, including marine protected areas. So now it's possible to establish a comprehensive system of area-based management tools. And I am going to start abbreviating these things to ABMTs, because that's one thing about this treaty. There are lots of abbreviations that have crept in the negotiations over the years. Certainly, and also will allow for the establishment of ecologically representative and well-connected networks of marine protected areas. This is certainly novel. Another issue I want to highlight, and then I'm going to pass the torch to Konrad to leave him something, but is that it also operationalized the provisions of the convention relating to environmental impact assessment. And not only did it achieve that, but it also now provides for the possibility to also conduct strategic environment assessments. And anybody who will look at the treaty will find, and it's not yet, I'm calling it a treaty, I'm going to have to call it a draft agreement because it hasn't yet been formally adopted. Anybody who looks at that will see that that is actually one of the largest parts of that treaty. So I'll pass the torch to Konrad, but perhaps also just one thing I wanted to also flag is the institutional arrangements that have been introduced by this treaty, which will definitely provide for allow the international community to have a greater say in the conservation and sustainable use of marine biological diversity of areas beyond the national jurisdiction, to which we do refer to as for short the BBNJ.
Thanks so much, Gabriele. We will come back to these institutional arrangements, which are too many actually. We'll see how they will work in practice. Konrad, any initial thoughts, remarks?
Thanks. And obviously, I'd like to start off by thanking and appreciating your kind invitation. It's an honor. Secondly, in full disclosure, I'll just say that I've been a member of the Polish delegation and I'm a member of the EU negotiating team on MGRs. But obviously, whatever I say as myself, and not necessarily to be attributed to myself or the EU. I completely agree with the previous speaker, so that's boring. So I'll try to take slightly different perspectives, like maybe in particular for those that are not that familiar with the treaty. I'd like to offer a bit more, let's say, formal outlook on the BBNJ agreement. Indeed, there will be a lot of abbreviations, I'm sorry. But I think first thing, which is obvious, but it was not obvious at the beginning, is the implementing agreement to UNCLOS. It's under UNCLOS. And then at the beginning of the debates that Tire was referring to, I remember sitting a long debate whether it should be under the CBD, the Convention on Biological Diversity, or UNCLOS. So it's under UNCLOS. So in this sense, secondly, it's kind of similar to the already existing two implementing agreements, in particular one. Because the two implementing agreements have different status. The sort of Part 11 implementing agreement is basically so tied so closely with UNCLOS that you cannot be a party to it separately. The Struggling Fish Stocks 1995 agreement is more autonomous, so you can be a party of it, not being part of UNCLOS. And this follows that path, legal path. So you could become a party to this BBNJ agreement, not being party to UNCLOS, which is maybe not unprecedented because 1995 agreement did it, but it has some nice, interesting, potentially implications, legal, geopolitical maybe, but also for example, dispute settlement mechanisms when there is a quite complicated setup of issues, how that would apply for parties or non-parties. Thirdly, I would just say that it's in 2011, the so-called package was agreed, and there are like 4 main elements to the treaty. So we have EIAs, environmental impact assessments, ABMTs and NPAs, so area-based management tools and marine protected areas, marine genetic resources, and capacity building. And what I would like to, basically Tire and Gabi already mentioned it, but I'm going back to my first point that it's under UNCLOS. It is under UNCLOS, but I think when you look at those different parts of the treaty, it's differently under UNCLOS. So especially with regards to, let's say, EIAs and capacity building, you could claim that you already have rules in UNCLOS for that. It's just they're developed somehow. For MGRs, yeah, there probably still is a big debate to what extent they are or they are not covered, but certainly the word MGR or marine genetic resources is not there. You could try to argue that it's somehow under natural resources, maybe addressed in a broad sense. Certainly the digital sequence information, which is again something that we borrowed very heavily from the developments in the CBD forum, is something that's very novel and not really law of the sea like, I would argue. And finally, you have MPAs, or APMTs, which is basically a new mechanism that was lacking under UNCLOS. And on top of that, you have, as Gabi mentioned, pretty strong, to me, somewhat ironically so, institutional setup, which is much heavier than the UNCLOS, which is relatively sort of famous for it lacking the sort of classical COP as we know it from environmental treaties. So the mother treaty here will be less robust, and here implementing agreement will be quite robust. And on top of that, you have a pretty interesting, I would say, maybe even unprecedented financing, not only of the institutions, which is normal, but also of benefit sharing and capacity building, which is certainly not something usual. And on top of that, you have, well, with nuances, and I know Joachis also specialized in that, dispute settlement mechanism, which is kind of replicated from UNCLOS with, they have some tweaks and nuances, but after all, you know, UNCLOS is the constitution of the oceans, and one of the reasons it being the constitution, and this pivot upon everything is the dispute settlement mechanism. So it's, I think, going back and finishing with that to what Pierre said at the introduction, it's pretty nice nowadays in terms of like multilateralism, treaty making, that dispute settlement mechanism for which UNCLOS is famous for is replicated here. That I think it's a good and important feature of BBNJ. Thank you.
Thank you, Konrad. Thanks so much. I fully agree that dispute settlement is really key to the future implementation of the treaty. Dear, you have a comment?
Yeah, I just thought maybe in the interest of sort of the interactiveness of the discussion, I might sort of jump in and say, I mean, I think that the summaries that were given by Gabby and Konrad were really interesting, and I agree with both of them. There's just maybe one point, and that's concerning the extent to which the MPA part of the agreement is quote unquote new. So I actually think, much like the EIA part, the MPA part is really giving effect to what's already in the Law of the Sea Convention, because the Law of the Sea Convention is all of these provisions that say, states should adopt measures either individually or collectively. So in a sense, it's kind of like encouraging states to adopt measures collectively. In this context, in the context of an institutional setting. As you were speaking, Konrad, I was also thinking that maybe the MGR question can also be looked at in that way. But I think there's something that makes that slightly different, and that's that there's a huge departure in the MGR section. The Law of the Sea Convention, as we all know, I think we all teach it whenever we teach, we keep saying it's based on this quote unquote zonal approach. There's a distinct departure with respect to the MGR section. It's not based on a zonal approach. And in fact, when the discussion first started, remember, the discussion was purely about MGRs in the area. But that's not how it was addressed. And of course, there are very good scientific reasons why it wasn't addressed that way, but that's not how it was addressed. I just thought I'd make those points of agreement.
Thank you very much, Dire. Now, speaking of what actually is the implementation of existing provisions and what is practically new, let me ask you about the basic principles that have been incorporated in the treaty. There has been a lot of discussion since the beginning of the negotiation, the informal and the formal, about which should be the guiding principles of the agreement. So how do you see these? One question was how we can reconcile common heritage of humankind and freedom of the high seas, but also if the traditional knowledge and the rights of indigenous people would be safeguarded. And at the very end of the day, if the access and benefit sharing regime was going to be fair. So, Gabriele, you have the floor.
Thank you. So those three questions are quite broad. On the first one, I don't think they're opposing principles. The common heritage of, and it's been changed to humankind, gender sensitive, which is good. And the principle of what is reflected in the treaty as, well, actually, it's not called a principle, which is quite interesting. It's just mentioned as the freedom of the marine scientific research and other freedoms. I think the agreement tries to balance these two principles. I still think it's a principle, the freedom of the high seas is also a principle, but that's my view. And you can see this also in the part on marine genetic resources, including questions on including the fair and equitable sharing of benefits, where the article on objectives provides for both the fair and equitable sharing of benefits from activities with respect to marine genetic resources and digital sequel information on marine genetic resources, and the building and development of the capacity of parties, particularly developing states parties, and the development and transfer of marine technology, but also the generation, knowledge, and scientific understanding and technological innovation, including through the development and conduct of marine scientific research. So both of these objectives are reflected in part 2. Also, the article on international cooperation provides that requires states to promote international cooperation on marine scientific research. And the agreement, in effect, doesn't affect or prejudice the other freedoms of the high seas, navigation, for example. Or it doesn't set out to do so because, of course, there's also the requirement not to undermine relevant legal instruments and frameworks and relevant global, regional, sub-regional, and sectoral bodies. Certainly, so the two principles, I think, can sit side by side. With respect to the second question, I treat them as separate question. Will the traditional knowledge and rights of indigenous peoples be safeguarded? In my view, yes. In fact, in the preamble already, there is an affirmation that nothing in the agreement shall be construed as diminishing or extinguishing the existing rights of indigenous peoples, including as set out in the UN Declaration on the Rights of Indigenous Peoples. The agreement also provides that in order to achieve the objectives of the agreement, parties shall be guided by the use of relevant traditional knowledge of indigenous peoples and local communities where available, and the respect, promotion, and consideration of their respective obligations as applicable relating to the rights of indigenous peoples when taking action to address the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. In the part on marine genetic resources, there's also an obligation for parties to take the legislative, administrative, or policy measures where relevant and as appropriate, with the aim of ensuring that traditional knowledge associated with marine genetic resources in areas beyond national jurisdiction that is held by indigenous peoples and local communities shall only be accessed with the free, prior, and informed consent or approval and involvement of these people and local communities. And access to such traditional knowledge may be facilitated by the clearinghouse mechanism, and it's to be access and use of such knowledge is to be on mutually agreed terms. Furthermore, the agreement provides for consultation with indigenous peoples in the context of the establishment of area-based management tools, including marine protected areas, and in the context of environmental impact assessment. And also indigenous peoples are to participate in various bodies, including in the Conference of the Parties. The rules of procedure of such Conference of the Parties is to provide for such participation, and also their knowledge in the scientific and technical body their expertise is to be represented in selecting members of such body. So definitely, I don't, there's a lot of agreement to safeguard these measures. Now, with respect to the third question, since I think I've spoken already at length, I'd be happy to pass the mic to my dear fellow speaker. Thank you.
Thank you, Gabriele. Konrad, you were actually the coordinator of the EU concerning marine genetic resources. So what is your comment concerning principles in this respect?
Well, your introduction made it significantly harder for me to comment. No, but jokes aside, well, I think I agree to a large degree with Gabi when she was trying to make a point that at least generally speaking or theoretically speaking, there is no immediate opposition between the common heritage of mankind on the one hand and the freedoms here indeed in the treaty referred as marine scientific research and other freedoms. Perhaps like for historical reasons, I would just say what Dira mentioned in the previous question, that debate, I mean, the debate about the underlying principle was with us basically since the inception of the debates and basically stayed till the last hours of the last marathon negotiation. And it's a very important one. I would say ultimately, I would argue that it's a compromise, obviously, whereby I think you were referring to those general principles and approaches in Article 7 and enshrined in Article 7 of a treaty when you have a whole list of principles, those including, but actually some 10 more. And I tend to look at these as, I think Ronald Dworkin used to make this differentiation between rules and principles, and rules operate on the basis of either or, so it's 0-1. Principles operate more on a more or less basis. So two principles can be implemented at one time, where two rules cannot. And I try to look at those particular controversial, historically speaking, with regards to those debates as exactly those. So there is a bit of both principles represented in a treaty. Obviously, the common heritage of mankind is not perhaps implemented to its fullest if we take the fullest as it was done for UNCLOS, and then you have the ISA and the minerals and the whole regime for developed for that. So we didn't go that far. On the other hand, it's also, which was one of the arguments against the existing regime, that it's a first come first serve, that it's almost no rules. Even though I don't personally agree with such a description, indeed you would have freedoms, in particular perhaps with regards to marine genetic resources. It's not so much the freedom of navigation, but rather indeed the marine scientific research that is the most important one. And that, on the one hand, that principle still applies. And when you look at the MGR's part, you will see that every state has the right to conduct these activities on MGRs. But on the other hand, there are additional rules qualifying how exactly you would do it. And both in terms of what you do, we called it, I think, pre-cruise, what types of information and activities you're obliged to take before the cruise, and how, and then perhaps even more importantly, what happens after the cruise, that you sort of store either the samples in collections or repositories, or the digital sequence information about MGRs, which is more sort of up to date with how science actually works nowadays. That you store it in publicly accessible databases. So this is follows, I would say, the idea of the freedoms, but also I think reflects upon the fact that it's a common space, a common resources, and access to them should be common to the as much as possible. So this in and of itself is an added value. And on top of that, you have a very elaborate system of financing, and well, sometimes it's almost difficult to differentiate between benefit sharing and capacity building. But in this in MGRs, we talk usually about benefit sharing that is supposed to aid all states, but in particular developing states, in being able to conduct and well, basically take stock of the novelties of science, to make science and to understand science, to take use of either marine genetic resources or information about them, be it ESI or something else. And also you have an embedded mechanism that could pop up at a certain point, which is in particular when the utilization of MGRs would start, then you could, the system of financial benefits would actually be changed and be based more, instead of quite specific sort of assessed contributions, into benefits that would be shared to all based on the utilization. So this is the argument that if you know, again, if these are common resources and some commercialization would take place, then the benefits to some extent should be shared among all, to simplify. So that's, and then I probably spoke too long, so I'll skip the indigenous part question. And on fairness, it's obviously a philosophical question and it's very difficult to answer. I will just say that I think there is a lot of provisions, be it in the MGR's part, be it in the capacity building and in all the remaining chapters, that try to build in mechanisms for transparency, for fairness, and for sharing of various types of information. But ultimately, and it's not very innovative of me to say, but a lot will boil down to implementation, and how fair will it be? It also depends on how actually the system will work, which is conditional on how, for example, COP and all the institutions will work, and what specific rules will be devised to implement the treaty. Some tester, but it's not the fairness of the treaty itself, but the perception of its fairness, will probably already soon, when we'll see the ratification or ratification rate. So that will probably show, in a sense, how states, at least, how they perceive it. Is it a fair deal? I would hope so, certainly. And those 60 ratifications that are needed, I would hope to see them sooner rather than later, which will, in and of itself, will be kind of an indicator how at least states perceive the balance and fairness in the treaty. Not only fairness, but also balance of rights, duties, and obviously that should be in line with general UNCLOS logic. Thank you.
Thank you, Konrad. So, Dire, what is your take on that?
Yeah, thank you. Well, so first of all, I'm really glad that I get to go last, because I think my response is basically going to be given in the context of the two previous responses. And I should begin with a disclaimer and just say that I was involved with the BBNJ process pretty much up until 2019. And so after 2019, now and again, the G77 would call upon me privately to ask me some questions, but I wasn't involved in the negotiations. And so I know the first thing I know, which actually surprised me, I just saw it now, was that the negotiations finally ditched mankind in favor of humankind. I still prefer mankind, by the way. You know, we can have a debate about that later on. But Konrad, I found your response very interesting, because you began by saying you agree with Gabby, but I sense some disagreement with Gabby. But you didn't want to say you disagree with Gabby. And in fact, I more agree with you. I think that there is a very clear tension between the two. I mean, maybe to explain sort of at least my perspective of this tension, for me, the common heritage of mankind has never been just about the marine genetic resources part or about benefit sharing. It's about the whole instrument. So even the MPA part for me is about common heritage of mankind. And the tension basically is the freedom of the high seas says, well, you do what you want. The common heritage of mankind is a restrictor principle to that, right? It sort of accepts that this freedom exists, and then it lays particular rules down which limit to a greater or lesser extent the freedom of the high seas. That was done in the Law of the Sea Convention initially. Right? You had these limitations, again, not just with respect to Part 7, not just with respect to Part 11, but even in Part 7, there were limitations to the freedom of the high seas, even in Part 13 and so on. So the whole framework of the law in this area is, for me, geared towards limiting freedom of the high seas. That's the whole, because these freedoms exist at the point of departure is these freedoms. And then these freedoms are limited by rules that we set down. And what we see in the BBNJ agreement is a further limitation of these principles. I'm sorry, it's a further limitation of these freedoms. That's what we see, not just with respect to the MGR section, but also with respect to the other provisions, right? So with respect to EIA, with respect to MPIAs, it's a gradual, if you like. In fact, in the very first piece that I ever wrote on BBNJ, which was in 2007, I described the problem, these two problems that I began with, as a problem of really the freedom of the high seas, which ought to be resolved somehow, including by means of an implementing agreement. So in that sense, I think there is a tension. And I don't think it's by accident that we have a reference in the agreement to the principle of the common heritage of mankind, but you don't have a similar reference in respect of the freedom of the high seas. You have not the principle of the freedom of the high seas, but you have freedom of marine scientific research together with other freedom. It's not an accident. And in fact, in the previous versions of the agreement, that wasn't there, right? This is a new insertion. I don't know at what point it was inserted in the instrument, but I know that as late as 2022, there wasn't that provision. And I think it was, again, probably a recognition that the purpose of the instrument is to limit, if you like, so the freedom of the high seas, and I'm sure that there were some that thought, well, we need to somehow reflect the fact that these freedoms still exist. I don't think anything that I've said is undermined by the fact that there still exists in Part 2 on marine genetic resources, the freedom of scientific research. Of course it does. But I don't think it undermines the fact that there is this tension, and I don't think it undermines the fact that the insertion of the principle of the common heritage of mankind is in fact intended, in a sense, to sort of say there are these freedoms, but they need to be limited, and that's the relationship between the two. And of course, I absolutely agree with Konrad that ultimately the question of fairness is a question which is in the eye of the beholder. The only thing I will say, though, about Part 2 of the agreement is that I'm really surprised, and pleasantly surprised, by the way, by the extent to which the aspirations of developing countries are reflected in Part 2. I think it wasn't clear to me, for example, the last time I was involved in the negotiations, that there would actually be an inclusion of monetary benefits. Now, of course, exactly how that's going to be is sort of kicked down the line, but at least it's there, and I think that's I think that suggests at least some cause for celebration.
Thank you, Dire. I think Dire works very well as a commentator to the previous speakers. But I think we have a reply from Gabriele. You're muted, Gabriele.
Yes, thank you. I think it's, I think I have to come back on the issue of the freedom of the high seas. I think one thing that is important to remember, this is an agreement under UNCLOS. And even in UNCLOS, the freedom of the high seas are not unrestricted. And I think that's an important message to bear in mind. Now, this famous wording that is there right now was actually inserted at the 11th hour. In informal consultations, so we don't know actually what the discussion went on. I can only imagine, I know from the previous discussions that actually the developed countries didn't want a reference to the common heritage of mankind or humankind. And so this was obviously a last minute compromise to include some reference as a balancing act to what was included in the context of the common heritage of humankind. So, so how much thought was given to it in a last minute 36-hour negotiation? I'm not sure. Konrad was there and probably can say more about that. But just to say that, yeah, no, not even in UNCLOS do we have unrestricted freedom of the high seas. Thank you.
So, Konrad, tell us what happened, behind closed doors.
It was too late for me to be able to think. I think that was somewhere between 2 a.m. and 4 a.m., something like that. So it's, and it's difficult for me to comment indeed on this. But I think here I really agree with Gabi. So it is a very last-minute compromise, and given the lateness of the hour or earliness of the hour, difficult to say how well thought through. Certainly, it goes without saying, it's relatively well known that the two principles were seen as not, even if not the legal opposites, then certainly like political opposites, and the two camps, if I may put it that way, put forward common heritage of mankind on the one hand, and then the freedom of freedoms on the other. And I think to a large extent, large chunks, if not all, of the part 2 on marine genetic resources were sort of negotiated not before that compromise happened. So actually, you could also obviously always claim that these or the other principle influence the thinking of states and negotiators in the proposals they put. But in essence, as at least to the best of my recollection, the thrust of the MGR's part, and I'm sorry for keeping to the MGR's part, but because I agree with the idea that the common heritage of mankind or the freedoms will permit every part of it, of the BBNJ agreement, but still, let's say it's most visible and mostly commented on from the MGR's perspective. But in essence, the thrust of the MGR's part was negotiated before that particular compromise language on the in the general principles and approaches provision. I will also just say, agreeing also with Dira, that perhaps I'll fear the word restricted, but let's say that freedoms, in particular the marine scientific research freedom, as understood in UNCLOS, is, let's say, qualified or developed in the BBNJ agreement in a relatively sort of creative and novel way, also to take into account of novel developments relating to how you do science and on what you do science. But also, I would just say that it's not necessarily due to the fact that it's restricted because of the common heritage of mankind principle, because you have a host of other principles, be related to ecosystem approaches, to precautionary approaches, integrated approaches, indigenous, lots of other principles which drives that drove the states and negotiators into finding the compromise, and also finding, I should stress, something that hopefully would both legally and scientifically make sense. So you could do science and scientific research, including on MGRs, and resulting DSI, and that exercise of doing science would not be hampered, would not be restricted on the one hand, but on the other, it would generate benefits of non-monetary values, such as generation of knowledge. Gabi referred to that it's in a few aspects of the treaty, and also sort of the monetary aspects of it. So it is indeed a tricky and delicate balance among, but not only among the two principles, but also trying to make it work. Thanks.
Did you have short comments because we have to move to the next?
Yes, I know. One last point. So just on that point, so I would say that I think those other principles, by the way, the precautionary principle, ecosystems approach, they're really all part of, for me, they are a reflection of the common heritage of mankind anyway. So that's one point.
Great, thanks so much. Now we covered, tried to cover the MGR part, one of the, the package deal, one part of the package deal. Let's go to the other components of the package deal, and let's turn first to the MPAs and how this hybrid approach, how this approach with respect to MPAs, the establishment of MPAs, the decision-making authority, the complementariness with already existing regional arrangements and other mechanisms, how this will work under the new agreement. And also in this regard, let's also discuss and I'd like your comments on the other component, which is the environmental impact assessment. There's been a lot of discussion with respect to the threshold of the EIAs, and also on the decision-making authority, which would rest with the respective state party, not with the COP, to decide whether a specific activity will take place after an EIA has been discharged. So I will start with Gabriele, because I think you mentioned, Gabriele, that there's two parts in your introductory contribution. So MPAs and EIAs, to you first, Gabriele.
Yeah, the MPAs, I think, as I had already mentioned, the agreement now, and I agree with Dire on what he had said earlier about UNCLOS provides the principle that it's possible to establish such areas, but the mechanism of how to do it is now provided in the agreement. So the process, let's put it this way, for the establishment of marine protected areas. And it's a transparent and very inclusive one, I should highlight. Also, it's open to consultation with all relevant stakeholders. That's an important aspect. There's also an element of control by the institutional arrangements. The submitting party, once it submits its proposal, may need to also need to take into account any comments that, well, first it's submitted to the scientific and technical body, which will review whether it's following all the necessary procedures, and then the submitting party may be required to revise the proposal. And after consultation, it will be assessed by a scientific and technical body, which will then make recommendations to the COP. Now, this is a bit different from the scenario that we have with respect to the EIAs, which are predominantly state-led, but where there are also checks and balances, and I will come back to those, if I may. The COP will consider, of course, all the inputs and the recommendations from the scientific and technical body, and then will consider the draft management plans and decide on the establishment of the area-based management tool, including the MPAs. And related measures. This is where it gets interesting, because if there is no, the shortcut would be to say IFB. If there is no relevant international instrument or framework or relevant global, regional, sub-regional or sectoral body, that's why we abbreviate it as IFB, then in that case, the COP will decide on the measures. But if there is already a body, then obviously any measure can be discussed will be discussed in close coordination with those IFBs, and the COP may take such measures that are compatible with those adopted by the IFBs. And it may do that, and it may also propose measures which are within the competence of another IFB. But in that case, it actually cannot dictate those measures. Those have to be taken forward by the parties to that particular IFB. And basically, so if that doesn't happen, then of course it's a problem, and that will be counter to the objective of the agreement, the conservation and sustainable use of marine biological diversity. So it's important to have, it is probably the ABMT, including MPA section, is very much relies on cooperation and coordination with the relevant IFBs. This is also true of the, by the way, the next section, but the EIA section. But what's really interesting is that, and really what's unique is that the Conference of the Parties, while it works on the basis of consensus, is able to take a decision by a vote if all efforts at reaching consensus have been exhausted. This means also that, it's not possible to block the adoption of a marine protected area by one particular state. It's also possible for a party to opt out of a decision that the Conference of the Parties may take. If, for example, such decision is inconsistent with the agreement or with the obligations of that particular state under the convention, or if the decision is held to discriminate unjustly in form or fact against the objecting party, or if the party cannot practically comply with the decision, after all making all reasonable efforts. Now, the drawback of that, of course, is that there is no time limit given as to how long a party can object. In fact, it's renewable every 3 years, so that's a bit of a drawback. I would say another problem in terms of the section that isn't really answered is how will these MPAs be monitored and enforced? We're talking about areas beyond national jurisdiction, far away from anybody's eye. We're relying completely on flag state enforcement. And while and the performance of flag states has not been even, there are those that operate at a not so high standard. So obviously there will be technology using satellites will play a pivotal role, but also perhaps down the line, the Conference of the Parties may need to think about how it will monitor compliance. And the other issue, of course, is yes, if one or IFB actually doesn't want to take any measures, or what happens if there are conflicting measures being adopted by the IFBs. These are questions that haven't been answered. I could go on to EIAs if you want, or should I perhaps leave it to my?
I mean, I don't know if Gabriele or Konrad wants to make a comment on the MPAs part, and then we can very swiftly move to EIA. So, Gabriele, do you have any comments on what Gabi said, or?
Very brief. I agree with everything that Gabi says. I'll just say a couple of things. Maybe I'll be brief. I won't even be more than a minute or two. I mean, this particular section, of course, is the one section that I think didn't give much problems, in the sense that already, I think around 2015, 2016, there was a basic sense of what the agreement would look like. The one thing that strikes me when I look at it, it was mentioned by Gabi as a pro, I guess, and this is this idea of the fact that you can make some decision, even if there's some disagreement. But it's a very high threshold for a decision. And I mean, that surprised me a bit. If I remember correctly, the threshold is 3/4, or I think it's a 3/4 majority. That's a really high threshold. Yep. And you only get there if there has been a decision, a positive decision, that we haven't been able to reach consensus. And even that is a very high threshold. I mean, it's a 2/3 majority. So that's, I must say, is the one thing that really struck me. But otherwise, I think that this portion of the agreement is one more or less what we all expected it to be. And I think it's a pretty good agreement. I mean, it could, of course, always be better. You could, of course, devise a measure which, contrary to the basic principles of international law, would allow the conference of the parties to sort of take a decision, and this decision would be binding on all states, even those that aren't party. But, that's not realistic. So I think it does what it reasonably could do. Yeah. I don't have much to say. Yeah.
Thanks, Derek. Konrad, any comment on this? Anything, any insight from behind closed doors?
Well, I was busy negotiating something else.
3 o'clock in the morning or 4 o'clock in the morning.
Yeah, but I would say just now, to me, at least people often walk by and said, "Oh, you're doing with MGRs. This is the most complicated part. I mean, this is so controversial." And I was like, "Yeah, maybe," but actually, a bit differently maybe than Tira. I always thought that, like, intellectually speaking, the ABMT's MPA part is a very hard bargain to make. Maybe not a bargain, but like a solution to be found, in a sense that, to my mind, to simplify a bit, we were always between two oppositions of one wanting to be effective, and on the other hand, this famous not undermine clause in the mandate. So you shall not, this treaty shall not undermine existing IFPs, let's say. So to me, that perhaps intellectual was not always easy to find a way, and also I know it was not an easy deal to be negotiated, to maneuver between those two icebergs, if you wish, and find something which I overall agree. It's a sensible solution, I think, overall, that whenever anything else has competence, you should cover it with that. If there's a lacuna, then the BBNJ can actually kick in. And this is indeed that process, which is very specific. It is pretty detailed, I would say, and ends with a decision. This is something I thought is new in UNCLOS. And I also thought that actually that 3/4, generally it's high. On the other hand, it was for a long time, and I think practice, that especially with regards to the establishment of such measures, was consensus decision making. So I was, it's a reasonable compromise, I would say. I think that the upside of this or downside of this compromise is what Gabi drew our attention to, is this possibility of opt-out. So something for something. If some states can be out-voted, basically, then they need to be able to opt out, like in a sense, in the tacit acceptance procedures, in like treaty making, IMO. So that's also to some extent understandable, and that renewal by 3 years, which is also not a very often used mechanism. In some Council of Europe treaties, for example, it is used. I've done it sort of for some. It's not easy, so it will give some. It is some restrainer, I would say. I would also, in this particular case, just because Gabi described it beautifully, how it works. Just two nuances, or maybe one nuance being the possibility to set up emergency sort of measures. That's also something interesting and novel. So, and then the whole process is sped up and simplified. Although in a nutshell, it should be temporary. It's actually quite interesting to see what natural phenomena or human-caused disaster, in particular, I think I have in mind natural phenomena, would be considered to meet the emergency threshold. And the other thing, since I think we're officially in Rome, or I mean we're online, but maybe we're steered from Rome, then I would just say, so being in a Mediterranean region, the other nuance being we're dealing in areas beyond national jurisdiction, but also what's currently beyond national jurisdiction, especially in the Mediterranean, is quite close to the seashore, may change. So something what's beyond may suddenly start to be within. And also here you have provisions for that. So it's quite interesting from that perspective as well. And that's it. Thank you.
So states will be, some state will be keen on, proclaiming EZs that they have not done, like my country, for example. Do you comment on then on, maybe to Gabriele and EIS?
Yes, and I apologize to the facilitators. That's what happens when one of the students isn't prepared. They can only speak after others have spoken because they have comments. So I was triggered by the comments made by Konrad, and I have two responses. So one is the undermine language, which of course you're right was ubiquitous in the discussions. Yeah, we can't undermine. I never quite understood what that text means, and in fact, in my discussions with those that I advised, I said, in reality, that doesn't mean anything because ultimately the text of the agreement will say what the text will say, and it'll mean what it'll say because ultimately, even though it's an agreement under so UNCLOS, it is a self-standing agreement. Or at least an independent agreement, and so it'll mean whatever it means. And I don't think that the undermining language really made much sense. And then maybe just to put into context why I thought that the threshold was really high. The threshold was particularly high when one considers that the Conference of the Party is not discussing this or is not taking this decision in a vacuum. It's taking this decision having received advice and recommendation from a scientific body. So here a scientific body, which presumably we trust, says, yeah, we think there's a need there to take measures to adopt an MPA. It's very strange then that you would expect, even having jumped that, then be expected to obtain a three-quarters majority. It seems really high when you put it in that context. I just sort of wanted to make that point. Thank you.
Thanks, Dira. Gabriele, do you want to sum up the basic points on EIS and especially the issue of decision-making authority?
On decision-making only, or
just basic, the basic points on how EIS will work, actually.
Yeah, well, EIS is the longest section, so
yeah, I know.
A quick sum up, I'm afraid, is going to be a little laborious. It has a lot of intricacies, and it was, apart from the section on marine genetic resources, including the fair and equitable sharing of benefits, one of the sections that took a long, long time to reach agreement on. So I'm going to have to cover all the nuances. Otherwise, I will throw myself into, deep waters here. Certainly, perhaps it was also interesting when the president came in after 36 hours of negotiation and announced that the ship had reached the shore. And here I'm going to basically quote her. She actually clarified that the environmental impact assessment shall be state-led. And she said that in order to promote transparency, there are provisions which allow another party to register its votes on the impact of a planned activity and for the scientific and technical body to make non-binding recommendations. However, the negotiating state's understanding is that the state decides whether an activity is under its jurisdiction or control. I must say, I was a bit surprised at that statement, but then when one looks at the section, which is still the longest, it actually does provide for the possibility and for a state to register its concerns. Now, I'm going to go through the stages, and I'm sorry, it's going to be a little long, but just to explain a little bit how this works. So for those who are, and maybe not everybody is familiar with the environmental impact assessment process, the agreement details different stages of the process for conducting EIAs. And if a planned activity may have more than a minor or transitory effect on the marine environment, and this is one of the thresholds, or if the effects of the activity are unknown or poorly understood, the party with jurisdiction or control over an activity is obliged to conduct a screening of the activity. And this has to be sufficiently detailed and include, for example, an initial analysis of the cumulative impacts. And that's quite interesting because that's also a challenge. Based on this initial analysis, then the state determines whether it needs to conduct a full EIA or not. And so, and if determines that the activity will cause substantial pollution and harmful changes to the marine environment. So both the determination and analysis that the state conducts at the screening process has to be shared through the made public through the clearinghouse mechanism. And it's at this point that other states, of course, can have a look and see what exactly how the state reached that decision. And it's possible for a state, another state, having considered the best available science and scientific information and relevant traditional knowledge of indigenous peoples and local communities, it can register its views on the potential impacts of a planned activity and express its concerns, in which case the party that made the determination that there's no EIA required is supposed to consider these views. And so then the scientific and technical body is actually going to wait and see what the state that made the determination is going to do and how it will address those views. But at any rate, it will consider the views expressed, the concerns expressed, and the responses, and then make recommendations to the state that made the determination. All of this information and the party that made the determination must give consideration to the views of the and recommendations of the scientific and technical body. And all of this information needs to be made publicly available. Now, if an EIA is required, then the parties must also undergo scoping, other stages, following stages: scoping, impact assessment and evaluation, prevention, mitigation, and management of potential adverse impacts, public notification and consultation, and preparation and publication of an environmental impact assessment report. So, and again, during these, there are requirements to conduct, I highlight the requirement to conduct consultations, because that again allows a broad range of stakeholders, including the scientific and technical body, to present their views and comments. Now, once a party then has prepared a draft environmental impact assessment report, which includes a description of the planned activity, a baseline assessment of the marine environment, which is likely to be affected, a description of potential impacts, it is and makes this available again through the clearinghouse mechanism, then there is an opportunity for the scientific and technical body to consider this and evaluate the report, and also for a state to express its concerns and register its concerns. So there is a sort of a check and balance, if you wish, and in which case, if again, a state registers its concerns, as in the previous process that I described with respect to the screening, the state must take this, should take this into account, and then also the scientific and technical body will look to see what the response is from the state that made the determination, and then again make its recommendations. So there are some checks and balances, and also in the context of parties that are required to report on the impact of authorized activities and the results of monitoring through the clearinghouse mechanism, there's again an opportunity if the state with jurisdiction or control over an activity identifies significant adverse impacts that were either not foreseen during in the EIA process in nature or severity, or that arise from a breach of any conditions set out in the approval of the activity, the party must review its decision and on authorizing the activity and notify the conference of the parties and other parties and the public, including through the clearinghouse mechanism. And it must take measures to prevent, mitigate, and or manage those impacts. Now, if it doesn't do that, and the scientific and technical body can also basically also based on the information that it has and the reports that it receives, it can also bring this to the attention of a state and ask it to take measures. So that I think perhaps I leave it at that, and perhaps I should just also mention that the scientific and technical body is also going to be developing standards or guidelines, and those will be important regarding the conduct of an environmental impact assessment. There will also be an implementation, there's also an implementation and compliance committee that is also relevant if there is a breach. And Konrad already mentioned the possibility to take emergency measures, also if humans have caused a disaster or that has caused or is likely to cause serious or irreversible harm to the marine environment. So while everything is left most of the time in the hands of states, there are some checks and balances.
Thank you, Gabriele. That was actually very comprehensive. And I think it gives a good idea of the complexity of the treaty. So I think it would be interesting to also have some questions from the audience. And since institutional aspects were actually addressed in different comments, let me end by a hard question. You have dedicated much of the last 20 years of your lives to this BBNJ negotiation. Now, in light of the outcome, I know it's not yet a treaty, but the text is agreed upon. Would you say it was worth the effort? Does the final product actually justify all this effort or not? And what do you think is the future of this draft agreement? Konrad, you have the floor.
Thank you. Yeah, it's difficult to comment on 2 decades of your life, possibly, but let me say this. I was always some say realistic, some say skeptical in terms of whether we will actually conclude. So to me, the very fact that we were able to negotiate a multilateral treaty of a highly complex nature, ranging really different areas and topics, it's a sort of achievement in and of itself. That's one. 2, will it solve all the issues that oceans or broadly marine environment or even global environment is facing nowadays? Well, I don't think so. I mean, even if you look like the major stressors to even the oceans, and actually, I think I forgot now. I think even the preamble maybe refers to. I think that it must be a preamble. Third indent needs to address in a coherent and cooperative manner biological diversity loss, degradation of ecosystems of the oceans due to, in particular, climate change impacts, warming, ocean deoxinization, ocean acidification, pollution, including plastic pollution and sustainable use. So if you were to juxtapose those stressors to the oceans and what the treaty can actually achieve, it can achieve on some of them, but it will, like climate change being one of the sort of obvious global threats, including perhaps in particular for the oceans, will have to be tackled. I hope it will have to be tackled through sort of climate regime. I mean, I don't want to go into the sort of, it's a subject of basically 2 advisory opinions on 2 different courts in various aspects, but it's not to say that this treaty or UNCLOS cannot do anything. It's just, it cannot do miracles as once UNCLOS was commented upon in slightly different contexts. But overall, so I think I'm happy we managed. I'm happy we concluded. It is the end result is reflective of what was originally agreed, in particular in 311, the 311 package. It does address the package. Probably in some ways it's worse, so that some would expect in particular aspects of the package. In some aspects, I think it's surprisingly good. And I think in MGRs, I think Gira referred to it, I think it's above what I would have expected some time ago that is possible to negotiate. But obviously it's an eye of the beholder situation, and some others will have different opinions about that. And ultimately, I really cannot say what the future will bring. I certainly will hope that that would achieve at least that rate of certifications relatively fast, because we have sort of biodiversity goals which are approaching fast. And in order for this treaty to be able to be actually to contribute to 2030 goals and others, it would need to be in place very, 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 very soon. And it would need a lot of states, and it would need a pretty sort of good cooperation and implementation. And that's a lot of ifs. So I can only hope it will work. Thanks.
Thank you, Konrad. Direct.
Thank you. So I'll also be very brief. I mean, as somebody who already in 2008 was calling for an agreement, I think it's absolutely wonderful that states were able to come up with this agreement and to do it. So when they did it, particularly when you take into account how complicated it was. Now, of course, we say these negotiations have been taking place for 19 years or whatever it is. But in reality, the first couple of those years were not negotiations. There were discussions to sort of see if there was a problem. So in a sense, it's not, I mean, it's long, but it hasn't been as long as we like to say it has been. For me, really, the beauty of the agreement is that it takes a number of issues forward. And I can give you examples with the MGR question, with the ABMT section. But since I didn't say anything about the EIA section, I'll give you an example. So using the EIA section, I mean, it's true what Gabby says, that ultimately, in terms of the agreement, lots of things are left to the parties. But actually, I'd go further than Gabby. I mean, Gabby pointed out the benefits of the EIA section, the transparency, if you like, the checks and balances. But I think there's even greater benefit than that. This text, this idea that the states shall consider the recommendation, that's very powerful. Now, it might not mean anything now, but when you're looking at it again in the context of the fact that you have a dispute settlement mechanism, a dispute settlement framework, I have no doubt in my mind that a court or a tribunal looking at this 15 years from now, where a state has clearly disregarded the views of the scientific body, but claims it has, will actually say you haven't done so, right? And I think that's an important improvement. So I'm really, really impressed by the amount of work that's been done by the delegates on this agreement. As far as where I see this agreement further here, I'll be a little more optimistic than Konrad. One, I think we have to be really honest. There are certain states which should ratify this agreement because of the impact that they have, and likely will not. But my hope looking forward, and this is the positive aspect, is that much like the Law of the Sea Convention, the state, particularly because they participated so heavily in the agreement, will not, and here the word undermine is relevant, will not undermine the agreement, will not act contrary to the agreement. And in that way, perhaps the content of these provisions and the rules that have been agreed may acquire the status of custom international law applicable to all. How's that for a positive outlook on the agreement?
That's a fantastically positive outlook on the agreement. And then from the outside, of course, we were all hoping the agreement would eventually come into existence. Now, Gabby, do you want to make any final comments on this last question?
There's not much I can add to what has already been said. I'm also among the optimistic people. I do believe it is a fantastic achievement, especially considering also the geopolitical situation. Of course, if one looks at it, there could have always been more that could have been included, but considering and having witnessed the complex debates that have been going on over the years, and I don't think one should, apart from different divergent views on how to regulate marine genetic resources, I think one of the big complexities has been the fact that there are already so many organizations that are active in areas beyond national jurisdiction. I personally can't wait for I'm eager to see how implementation is going to play out, because to see all these various actors, how will they interface with this agreement? The idea, of course, is that everybody's coexisting at the same level, but somehow in rereading the agreement, one does see a couple of nuances where there are reporting invitations to report to the COP or some of the subsidiary bodies by the IFBs. So I do feel that maybe down the line, and this is not about undermining, but that the COP will have a very central role in also bringing forward cooperation and coordination among the various sectors, which is one of the reasons also why we had this process in the first place, to address fragmentation. But of course, one will see how all of that plays out. I do believe also that, and I hope, and this is my hope, that with implementation of this agreement, fair and equitable sharing of benefits, equity as a principle, a robust capacity building, funding, with all of those ingredients, we actually will be able to level the playing field and be able to assist developing countries. And I think and whatever assistance is provided in the terms of capacity building and transfer marine technology that relates to areas beyond national jurisdiction will be equally relevant for them within areas under national jurisdiction. So I think, I hope that all of these activities will be able to help states and level the playing field.
Thank you very much. Now, I really want to thank you. This has been a really interesting discussion with many information from inside, but also with a lot of outlooks on what the future of this instrument is going to be. Now we have reached 5 Central European time, but I think we can stay online a little bit longer to address questions by our by the people who have attended the seminar.
Hello, thank you, Irini. Thank you so much to the panelists, to their opinion. And we have received 9 questions that the attendees asked the panelists. I would like to mention from the very beginning that all of them are very interesting, but due to the timing, I have to organize them in some way or another. Starting by trying to complement in some way or another the large opinions on the question that the panelists have told us. There is a question made by Manish Awana in relation to the military use and marine researches. The question is, does the treaty ensure measures to tackle the military use as a deceptive use in the name of marine researches? I would like to ask you if possible, to have an answer such as yes, no, maybe. Who would like to answer to this question, please? It is a general question.
I'll give a relatively formalistic answer, and perhaps others will wish to add it. I will just draw attention to at least two provisions of the treaty. One, and the numbering I'm giving might not be the one, because I just realized I'm taking the benefit of seeing the sort of more up-to-date version of the treaty than you might see at this stage. But in any case, at the beginning in Article 4, you have exceptions. And generally, this agreement does not apply to any warship, military aircraft, or naval or auxiliary. So there's a general exclusion, but there is also a inclusion there, except for Part 2. This agreement does not apply to other vessels or aircraft owned or operated by a party, and so on and so forth. And then you go to the MGRs, when you have somewhat famously the sort of fish exclusion in Article 10, but also then you have the obligations in this part shall not apply, this being the part on marine resources, shall not apply to parties' military activities, including military activities by government vessels and aircraft engaged in non-commercial service. Those provisions are longer. For sort of sake of time, I will not read or comment upon them, but I think they just at least give, I hope, direction to the answer of the answer.
Okay, thank you very much. Well, there are several questions related to the ratifications process. One question made by Jacques Hartmann is related to the possible political support for the BBNJ agreement and how this may translate into ratifications. The general idea of these questions related to the ratification is how many years we would need in order to have the BBNJ treaty into force, or maybe this treaty may be a good and quick answer to the climate changes issues. So, thank you. Who would like to answer? Yes, Gabriele, please go on.
So, well, 60 instruments of ratification, acceptance, approval, or accession are required for the treaty to enter into force. We have heard expressions of generous support and the hope that this treaty will enter into force early. So, of course, what is critical at this point is to ensure that there's awareness raising of this treaty, what it contains, and also to, first of all, encourage signatures of the treaty. This is always usually the first step in the treaty process. And so it is hoped that the treaty will be open for signature, presumably this year, maybe during the high-level segment of the General Assembly, when the Secretary General hosts an annual treaty event. And that would be an opportune moment for heads of state or heads of government or ministers of foreign affairs to actually sign the treaty. How many states will and how quickly this treaty will enter into force? Well, if one looks at the coalition, the high ambition coalition, and the number of states who have signed up to that, I can't remember the exact number, but it's a quite a large number of states. So perhaps it shouldn't take too long before, if those states are actually will follow through and also become a party to the treaty or ratify the treaty, then that would already go a long way towards getting it on the ground. It is also important not to enable all states to also have the capacity to become a party. And this is where I think one also needs to consider assistance to developing countries that may need it in order to help them deal with the ratification, the national process, perhaps in terms of also providing advice as to what elements need to be taken into account in national legislations that will enable them to become a party. I think early support funding to assist these developing countries will be critical, and awareness raising, as I've mentioned. And also, I would just add, it's not just about, and of course, in the meantime, in the interim, it will be important to have already work ongoing to prepare for the entry into force, and because the first conference of the parties has an extremely heavy workload, it needs to set up all the various subsidiary bodies and already take a number of important decisions. So it will be critical to also already work towards that, towards the objective of entry into force. Thank you.
Thank you, Gabriele. Yes, please, Konrad, you was the first.
Thanks. I just very briefly, I think I just wanted to in a sense, comment on top of whatever Gabi said, which I agree, that there's been, from my perspective, quite robust. I maybe don't have that much comparison with other sort of treaty making, but by NGOs. And there's been a lot of sort of pressure, awareness raising, and I would expect that will continue, and that may play a role. Secondly, in terms of money, I think the EU has pledged 40 million euro, if I remember correctly, on early ratification. So that's a pledge, and I wouldn't exclude this will be supplemented by other pledges. So there is actually quite a substantial, I think, money in a pocket for that sort of early ratification help, which Gabi referred to. And thirdly, which also might help, and Gabi alluded to it, is that the first COP and COPs, but particularly the first COP, will be quite crucial. And I would expect many states to be willing to be on board then, because it's going to be important. But we'll see. Thank you.
Thank you, Konrad. Please, Dire.
Yes, I'll be very quick. I mean, I agree with everything that was said by Gabi and Konrad. It seems to me that the speed of ratification of this instrument is going to be pushed because, one, there's a very large group of states that really wanted this agreement. And two, there's another large group of states that sort of sees much benefit in this instrument. So I think that because of that, those two factors are going to result in a fairly speedy ratification of the agreement.
Thank you very much. And one final question. I know that all the questions are very important. Some of them have been answered some way or another by our panelists. I just want to address a last question. It is in relation to the climate change. Climate change is something that has been mentioned by different questions. Do you think that this future BBNJ treaty is a good tool in order to fight against climate change? A brief answer, if possible, please, for each panelist. Thank you.
Well, I'll start. I mean, I think that it will certainly contribute, but I think it was Konrad that said earlier that we cannot see it as a solution to climate change. Again, if you sort of try to think back to one of the parts of the agreement, the EIA part, one way that would have contributed, of course, is if the activities attracting an EIA or requirement for an EIA included activities also within the territory of a state, but it explicitly excludes that. So again, we see that there are limitations. So obviously the climate change issues are going to have to be addressed primarily within the framework of the climate change regime. But of course, there'll be some contribution that the agreement will make.
Perfect, thank you. Yes, Gabriele, please. The microphone, please.
Sorry, keep forgetting. It's significant that the treaty actually provides this link to climate change. And I think clearly identifying it as one of the drivers of marine biodiversity loss. So I think that's really important. I think certainly the establishment of area-based management tools, including marine protected areas, will certainly contribute towards building resilience. And I think that is a major contribution that the treaty can make. And Dire already alluded to the environmental impact assessment provisions, which will also help address any particular assessment or of any proposals that go in the direction of marine geoengineering. So I think that's also important that we don't end up transferring one form of pollution to another. In terms of mitigating airborne pollution or greenhouse gas emissions further from shipping or any other activities, or from oil and gas operations on the high seas. But certainly if there were oil and gas operations on the high seas, that would be controlled within the EIA regime. But other than that, I don't see particularly the treaty dealing with those issues perhaps down the line. Thank you.
Thank you very much for your answer, dear panelists, and thank you the attendees that have asked these 10 questions finally, and of course all the other persons that have understood that these questions represent their own questions as well. Thank you very much. Irini, I give you the floor.
Thank you very much. So I think it has been a very intense, a very lively discussion, and all the comments actually provided us with much to think about. So I will leave it to Pierre to close the webinar and thank everyone.
Thank you very much, Irini, and thank you very much, colleagues, for having participated in this webinar. It's great to have you had here with us. Thank you to the participants also. I think we learned, all of us, we learned a lot from your contributions, and I look forward to other webinars with ESIL, with the participants, and eventually to meet with you sooner rather than later. Thank you so much, and again, good evening, good afternoon to everyone. Thank you so much. Goodbye.
Thank you. It was splendid. Thank you. Bye-bye.
Bye.
Bye. Thank you.